A major legal fight is brewing down there in the state of Texas in federal court in the Northern District out of Fort Worth. A big fight over a long-standing ATF law that says you cannot buy a handgun from a federal firearms licensee outside of a state in which you reside. Crazy, crazy law. It's been on the books for some time. It's being challenged under the Second Amendment by Elite Precision Customs LLC, a gunsmith, as well as the Firearms Policy Coalition, all attacking the ATF, and rightly so. Let's break down what's going on with this case and their most recent filing that tees up what I suspect will be a major win for the Second Amendment very soon. Hey folks, I'm Mark Smith, host of the 4 Box of Done, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say the top voice of the Second Amendment in America. Thank you, 2025 Gundies Awards. All right, so we have a huge fight brewing down there in Texas. This is a big one because a win in this case may very well set a precedent for the rest of America to get rid of that absurd law, that absurd rule that says I can only buy a handgun and take possession of it in a state in which I am a resident. So if I want to buy a handgun in another state that I see in an FFL that I think is really, really cool, I can't just buy it if I'm not a resident of that state. Instead, I can buy it and then I get to spend a bunch of money and ship it to an FFL in the state in which I am a resident. You don't do this with other products. If I want to buy a car in another state, I can buy the car. I can write my check and take the car. And so on and so on. But for some reason, they've made it hard because, of course, we've been controlled in Washington for several decades by a bunch of anti-gunners. So they basically enacted this law, and the ATF is helping enforce this. But this has now been challenged by the Firearms Policy Coalition and a gunsmith and FFL Elite Precision Customs LLC and some gun trainers and other individuals that are standing up for our right to keep and bear arms down there in Texas and across this great nation. Specifically, here is the law that is now being challenged in court in this case of Elite Precision versus ATF. The non-resident handgun purchase ban. The federal laws at issue in this case make it impossible for a peaceable American who is not prohibited for any reason from possessing firearms to purchase a handgun from a federally licensed firearms dealer unless that dealer is located in, you guessed it, his home state. Now, retailers are barred from selling or delivering handguns to any person who the dealer knows or has reasonable cause to believe resides in another state. And the restrictions do not apply, of course, to shotguns or rifles, and they do not prevent the transfers from licensed dealers in one state to dealers in another state. But, of course, they deal with non-resident handgun purchase bans. Well, that's the argument. And now there's these cross motions for summary judgment, really, where the federal government is saying, hey, this law is legit. It's justified under the Second Amendment's text. It's justified under the historical analysis required to be conducted by Heller and Bruin. We should win this case. This law should be upheld as consistent with the Second Amendment. Of course, the plaintiffs say that is a no-can-do. And here's how they argue the government's claims are simply hooey and frivolous, or at least borderline frivolous. The Second Amendment to the U.S. Constitution protects the right of the people to keep and bear arms. As the government freely admits, the laws at issue in this case, which bar the transfer of a handgun from a licensed dealer to a law-abiding and peaceable citizen of any of the 49 states where the dealer is not located, unquestionably burdens that fundamental right. The issue for this court to resolve is simply whether the government's ban is historically justifiable, and it is not. Despite throwing at the wall a wide variety of regulations and restrictions on the right that existed between the early 17th century and the early 19th century, the government does not cite a single law that burdened the right of peaceable citizens to acquire arms in another state or colony in any way like the law at issue here does, or for anything approaching the same reasons. That is simply fatal to the government's case here. Though it repeatedly stresses in its brief that the law at issue enacts, in its view, only a minor limitation on the right, the U.S. Supreme Court has foreclosed exactly that type of argument. Only history can excuse the government's regulation of the right to acquire handguns from licensed dealers, and history does no such thing. So that sets up the fight. Now, the bit of good news here is that the U.S. Department of Justice, the ATF under Donald Trump, has admitted and made a major concession that they should. It's a no-brainer. But the fact that DOJ did so is a positive. And that is, they have admitted that under the textual analysis, as you know, under Heller and Brune, you start with the text of the Second Amendment and you engage in sort of a semantic or a linguistic analysis as to what those words meant when they were adopted in the year of our Lord, 1791. And then, to the extent that the conduct at issue here, in this case, I want to buy a handgun in a state other than my own, but in America, textually, does that conduct implicate the text of the Second Amendment? And the government here, the Department of Justice under President Trump and Pam Bondi, has conceded, as well they should, that indeed the right to acquire a handgun, the right to buy a handgun, and by extension, presumably the right to sell a handgun, all of that gestalt, is indeed implicated by the text of the Second Amendment, which reads the right of the people to keep, which means to possess, and to bear, which means to carry, arms shall not be infringed. Now, obviously, the text of the Second Amendment itself, on its face, does not have the word to acquire, to sell, to buy. But by necessity, one cannot keep, possess, carry, or bear an arm if you cannot acquire it in the first instance. So because this law is a restriction by the government on our ability to acquire handguns, which are undeniably arms under the Second Amendment, because an arm is anything that can be used offensively and defensively. And the U.S. Supreme Court in 2008 in the Heller case said handguns are obviously arms semantically or linguistically. So the fact that the federal government here is admitted that the right to acquire firearms, in this case handguns, does indeed implicate the text of the right of the people to keep and bear arms shall not be infringed. This is a big concession because the anti-gunners try to play games with the text of the Second Amendment by arguing that virtually nothing is implicated by the text of the Second Amendment other than the right to possess and the right to carry guns. And even there, they try to play games. But here, as well they should, consistent with Supreme Court precedent, the Department of Justice has acknowledged the existence of concomitant or ancillary rights, which I've written about extensively in other places like AmmoLand and the Georgetown Journal of Law and Public Policy, explaining that indeed, like anywhere else in the Constitution, the text includes rights or activities that are implied or implicit in the text. And the fact that the Department of Justice here has conceded this point is a very big deal because, again, it is not the kind of point that anti-gunners would ever concede. And the fact is that DOJ under Trump and Pam Bondi have made this concession is indeed a big win for us. Because remember, as we've taught you before, to win the Battle of Japan, to conquer Japan, you have to island hop. You have to win brick by brick by brick. And now we have just won that the right to acquire firearms, the right to buy firearms and handguns is indeed implicated by the text. And the reason why that's so important is when you have a law like this one that says you can't buy a handgun and take possession of it from an FFL outside of your own state, it means what? It means the text has been satisfied and the burden shifts to the government. And because the burden shifts to the government, they bear the burden to show through history, not any kind of random history, but a specific kind of history, the historical tradition of firearms regulation. It doesn't matter whether or not Abraham Lincoln is gay. It doesn't matter what kind of underwear they wore in the Victorian era. None of that history matters. The only history that matters is the legal history of actual laws that were enacted, and is there a long-standing historical tradition of a set of laws in American life that is sufficiently analogous in terms of the why it was enacted and the how it was enforced, sufficiently analogous to the why and the how to the modern-day gun control law. And here you see that the government is throwing up a bunch of stuff against the wall to try to make it stick to justify this law, but I don't think they are going to succeed. And why do I say this? If you look at the laws that the federal government is using here to say these laws were on the books in American history at or around the time of the founding, and they justify and show a historical tradition of this kind of restriction on the ability to acquire a gun only from a state in which you're a resident, it simply, I think, doesn't hold water. To begin with, the federal government here uses a set of laws called proving laws, or some sort of manufacturing rules involving gunpowder. Now, if you look at these specific laws, it is clear to me that the laws that the government cites to justify this restriction that I can't buy a handgun in a state in which I'm not a resident and take possession of it then. The proving laws are simply a test, if you will, of a gun barrel at the time of the founding, and manufacturing rules and restrictions were specifically really consumer protection rules. So the way to look at proving laws, which is to make sure that if I shoot a barrel at the time of the founding or before the time of the founding and the barrel blows up in my face, that barrel has not been proved to work. Again, what we're talking about here are consumer protection laws. If you look at some of the laws cited by the federal government in this particular case to justify their restriction, they cite to laws really talking about, for example, they literally talk about the quantity or quantum of sodium nitrate that is to be in like black powder that's being sold to customers. Again, what you're seeing here is the federal government is citing to 18th century, in some cases even I think 17th century, consumer protection laws to try to say this is about protecting the consumer. But when you derive a principle from those laws, again, they're about protecting the customers. Now, let's ask ourselves, does this have anything to do with the how and the why of the modern day gun control law that says I am not allowed to buy and take possession of a gun in California today because I am not a resident? There is no connection between the consumer protection statutes and laws of the 18th century, which is about protecting me as an acquirer of a gun to make sure that it shoots, acquiring black powder to make sure it actually is black powder and will go bang bang when I pull the trigger, right? When I touch the pan, etc. Okay? Versus what's going on here, which is an attempt at restricting the ability for me to buy a gun in America, period. These have nothing to do with the price of tea in China, but these are the kinds of laws, these proving and manufacturing consumer protection laws are the sort of thing the government has thrown up against the wall to try to justify this modern law. The other thing the federal government has thrown up against the walls is really a set of rules. It's talking about, and this is quite interesting, they're trying to say, well, there are certain rules that says I could not sell guns outside of the town or the colony in which I live. But if you look carefully at those statutes and rules, they were very specific. They specifically dealt with a type of arm, specifically arms that were owned by the town, by the village, by the government, if you will. And all they were saying is, if you need a gun to fend off a foreign invader or Indians or whatever it is at the time, you can take the gun from the town armory, but you can't sell the gun and you can't take the gun outside of the town because those guns made available at the town armory were for defending the town or the colony or the county or the village or whatever it was. So when they say you couldn't take the gun outside of that particular area, that doesn't justify, again, today's modern day gun control law, which says I'm not allowed to buy a gun in a state in which I'm not a resident, because those laws dealt with government-owned guns and said, look, these guns are here for the county. You gotta basically keep them in the county because they're here to protect the county. Don't take them outside the county. That's not kosher. And then you had a series of laws the federal government is citing to, which I really call kind of export restrictions on the colonies. And this is actually quite interesting because it's true that there's some rules very early on, I think in the 16th century, maybe early 17th, dealing with colonies. These are different than independent states, by the way. These were really territories and colonies, some of which were controlled, listen carefully, some of which were controlled by the English, some of which were controlled by the Dutch, some of which were controlled by the French at the time. And there were fights among all these countries, and they involved, in many instances, the deployment and use of Indian allies. And there were certain restrictions that said you can't sell guns from your colony to another colony. This is way before the Second Amendment, by the way. I think this is like very early on in American life, had have nothing to do with the Second Amendment, but this was all about saying you can't sell guns to the English colonies, can't sell guns to the Dutch or to the French colonies because we're at war with them, and or because the French and the Dutch are giving the guns that we sell to them to the Indians, who are in turn attacking the English colonies. So again, this is really about national security laws. This has nothing to do with saying that Mark in the 21st century as an American citizen can't buy a gun anywhere in America. So these laws that the federal government has articulated and set forth to justify the modern day gun control law that we've talked about here is a bit of a stretch. In addition to being very early on, by the way, a lot of these actually predate, believe it or not, the English Declaration of Rights. They come from like the 1600s, the 1670s. So really, the timing is wrong and the how and the why is wrong. So again, we should win there. I should make a note. I did notice that this brief does cite to my article, Mark Smith in the Harvard Journal of Law and Public Policy, my article explaining that when you look at the relevant time period, it's always 1791 and not the 19th century, even though the anti-gunners always want to look to the late 19th century because there's a lot more anti-gun laws on the books in the late 19th century after the Civil War, in part because they were trying to take guns away through law from the freed African-American slaves. We probably should do a whole video on that at some point. But suffice it to say, the anti-gunners want to talk about the late 19th century gun control laws to show a historical tradition of gun control regulation, because there's a lot more gun control laws in the late 19th century after the Civil War than there were in 1791, which is the year that the Second Amendment was adopted and went into effect. And that's why the Supreme Court has repeatedly said is the relevant time period for assessing how to understand the Second Amendment, which means you look to the historical interpretations of the Second Amendment, and you also look to any historical tradition of firearms or regulation at that point in time, and not 100 years after the fact, after all of our founding fathers were long since dead and gone. So there you have it, folks. Hope you enjoyed today's episode on this case of Elite Precision versus the ATF. We'll keep you informed, but they have cross motions for summary judgment now for all intents and purposes, and we'll see what the judge does down there in Fort Worth, Texas, in federal court. It'll be quite interesting and see if there's a very good precedent for us in the Second Amendment. I think there's a good chance we can win this case, and I think there's a good chance the U.S. Court of Appeals for the Fifth Circuit would uphold a win in the district court. But again, as we've talked about before, the history of the future has yet to be written. So with that said, make sure you follow me on X at 4boxes. Don't forget to subscribe both to YouTube and to Rumble, and I look forward to talking to all of you again really, really soon here at the 4 Boxes Diner.
Orders up. Table 2A.